What's going on, everybody? It is 12:30 p.m. on Wednesday, August the 18th, 2021. I need my computer to tell me when this is because I have no idea what's going on. Anyway, make sure you guys follow me at True Perception 3 here on Twitter. I look forward to hearing from you guys. Like I said, if you contact me, let me know you're following me and you're semi-active, I will follow back. I don't know how important that is to everybody, but I do like to be involved with my supporters. Make sure you like this video. Give me a subscribe if you haven't already. It's a huge help. Make sure you hit the notification bell so you get all notifications about the fresh content being released daily, sometimes multiple times a day. Yeah, I got a Facebook page that you can follow over here. You can donate crypto at trueperception.crypto via supported wallets. You can get more information about that on Unstoppable Domains. The private Facebook group link is here. We would love to see you guys over there. I got my NFT account, which also has all my domains that are currently for sale, which there is a list of here. If you want to check some of those out, you can pause the video. I have several more on my OpenSea, like real estate photography.crypto, real estate photographer.crypto, headshot photography, headshot photographer, etc. Stuff like that. So enough of that. If you haven't watched my video from yesterday about Synchrony filing for a patent for a distributed credit system, make sure you guys take a minute to go check that out. It is a great video. R3 is mentioned, RippleNet, and XRP, and keep in mind that R3 Corda uses the XDC token internally to settle within a system, and then its second choice outside of the system is XRP. So this is a pretty major deal for all of that. Great stuff. It was mind-boggling to me. I saw it last night when we were watching Netflix. Netflix immediately came to an end and YouTube became a reality thanks to my overly understanding wife. Shout out to her. So yeah, anyway, let's just jump into what is going on. We covered all that. I have now finally found, I couldn't find it the other day, but I have located it now, that there is some of William Hinman's deposition has been out. So we're going to go over some of this. Crypto Law, shout out to John Deaton, just added to their document library Exhibit B to the SEC response to motion to compel limited excerpts of the Hinman deposition with redactions. Details are revealed of Clayton meeting with Ripple, where XRP status was discussed. Read it here. It's page 81 of 91. We're going to get into the whole thing here in a minute. This exhibit includes only a small number of pages from over 11 hours of deposition testimony by William Hinman, carefully selected by the SEC. The vast majority of the Hinman deposition has been excluded from this exhibit. This person says, why seal it and then show it to the public? It would just cause mass hysteria and confusion. And they respond with, the only pages made public in this exhibit were what the SEC wanted to be public as part of their arguments to oppose Ripple's motion to compel documents under Judge Netburn's discovery orders that they are refusing to produce. So we will see where this thing goes. Jeremy Hogan, apparently there were some portions of the SEC document that were deleted, which I found to be extremely interesting. And the deleted portion of the SEC document essentially states you can call 10 different law firms. They give you 10 different answers. Each of them has their own particular spin. It's like the white light of your speech went through a prism and came out in 10 different colors of legal advice. Doesn't sound very clear. You can even see me asking where I can find these documents earlier today, but I did find them. And here is the deleted part that was found in the metadata. And let's just read this real quick, because I'm not sure if this is in the main part or not. Maybe it is, but you'll see it was deleted. And they said, right. And I will represent to you my understanding is that Mr. Seaman deleted this portion of the document. Tenrera says, well, what's the basis of that understanding? Our review of the metadata, if you look to, depending on how you present it, but if you go to the second document, it says on some version of it, deleted by Michael Seaman. He says, I think there's no foundation to that right now in the record, but go ahead and ask the question. Let's open the native file, and I'll try to show you because I think it's important. Now, here's what is interesting. He preps his client and pretty much leads him into answering correctly, at least for their part of the argument. Even if it is, you can ask him if he directed Seaman to delete it. I mean, does he remember that? Did you direct Mr. Seaman to delete those subtopics? Hinman says, I don't recall directing him to do that. Do you have an understanding as to why he deleted them? Without disclosing deliberations or convictions, and he does not have a specific recollection of that, which is interesting. I bet he doesn't. Here, Jeremy Hogan had kind of made a a little bit of a joke, but here the actual testimony where what he said. The first thing I said to Ripple was, you're continuing to offer XRP without any kind of restrictions that would apply as a securities offering. If you want to come into compliance, you have to stop doing that. And we have a little clip that somebody had clipped out. Of course, this will be in the main part as well. And it says, pretty much the same thing. If you want to come into compliance, you have to stop doing that. And they understood that. And they said, okay, well, other than the issues with respect to Ripple, can you identify any other lawyers that came to you not seeking a no action letter, but seeking guidance with respect to transactions in digital assets? And Hinman does say yes. So people were seeking clarity. That much is apparent. I would love to know what gets said. I'm sure they're identifying some other parties here, and for whatever purposes that may not be privy for, we may not be privy to that for now anyway. We'll see. We're going to kind of scan through this entire thing. It's 91 pages. Most of it's redacted and black inked out. So, it shouldn't take us too long to go through it. Here we go. So, it says something about expertise with respect to the application of federal securities laws to transactions in digital assets. His answer says, I was someone in the firm that people came to with questions of that sort. So, sort of in the middle. It was new for everyone, but I had taken an interest in it and had studied it a little bit, so probably above average, but no one knew a lot. The question is why is it that no one knew a lot? Well, because the instruments were just being shaped and formed, and it was the early days of this activity. The question comes in again, and there had not been a lot of litigation as to when a transaction in a digital asset would constitute a security, correct? Mr. Tenrero says, I object, and Mr. Hinman answers, I don't believe so. So it tells you right there that because of the lack of litigation, there's no precedent here. How would somebody know? That's my interpretation. I'm not a lawyer, but it's what it sounds like to me. Here he's saying he doesn't think somebody was ever a client, but they might have been involved with matters I was involved in, but I don't think they were ever a client. Well, how about consensus? Nope. How about the Ethereum Foundation? Nope. And I mean this in a very broad sense. When I talk about the Ethereum Foundation, and I'm reading from language on their website, so if you'll bear with me, the Ethereum Foundation is not a company or even a traditional nonprofit. Their role is not to control or to lead Ethereum, nor are they the only organization that funds critical development of Ethereum-related technologies. The Ethereum Foundation, so with this very amorphous, broad definition of the foundation, do you believe you represented any company, individual, or entity that was involved in the Ethereum Foundation as it was just described? And then you don't even get to see what was said. I mean, that's what's crazy. Sealed. I mean, look at this. We got pages. The reporter, can I get a spelling on Ethereum? I'd like you to now direct your attention to the period after you announced your retirement from Simpson Thacher until you joined the SEC as the director of the Division of Corporate Finance. And you'll see it's skipping around pretty crazy, which I don't understand what the deal is with that, but whatever, we're going to have to deal with it. Because I didn't know what order we were going to be offering the documents. There's an internal document. So Mr. Hot Seater, I'm showing Mr. Hinman a document that is in the outline as Exhibit CC. I'm sorry, AA. Do you have Exhibit 6 in front of you? The only thing I have is my bio. So I show you what's been marked as Exhibit 6. I'll represent to you that I believe this is the Supreme Court's decision in SEC versus Howey. I just want to follow up on your earlier testimony that you said prior to joining the SEC you had familiarized yourself with Howey as it may relate to digital assets. Is that correct? Hinman says he believes so. Then the question was asked, approximately when was that? He answered mid-2016, maybe late 2016. Did you do that in anticipation of becoming the director of the Division of Corporate Finance? No. And then we got some more redactions. All right, so prior to joining the SEC, had you applied the Supreme Court's decision in Howey to any facts that you had at that time about under the federal security law? He answers again, we're talking about the first 6 months of my tenure. No, I did not. Again, it may have happened, but as you sit here today, you're not aware of it. Exactly. So he's not denying that these things may have happened. He's just denying remembering them, which is kind of like a deflection of responsibility in my eyes. It says, okay, I'm sorry. We've had a motion to take a break. Is that all right? Whatever you'd like. Off the record, the videographer says, a short break. Back on the record. We got some more redactions here. Things like heavily blacked out. I would love to know what some of these things say. The question was posed again. We will. I think we've created the record, and just so the record's clear, we don't believe that's an appropriate privilege instruction, but we'll move on. Before the break, I was asking about whether you were aware in, say, the first 6 months after you became the division director about various work product that had been created. Were you aware of any work product that had been created within the Division of Corporate Finance as to whether XRP or transactions in XRP were securities or investment contracts under the federal law? And again, this thing kind of skips around, so it's a little confusing. The question was asked again. So at any time the Division of Corporate Finance issued a no action letter, that would be publicly available. And he says that's right. So let's put aside the interactions with lawyers and the public that are requesting a no action letter. And he says, okay. Do you recall other issues that were brought to you and members of your staff about the application of the federal security laws to digital asset transactions in which they sought guidance without seeking a non-action letter? Yes. Tell me what you recall on that issue. He says, frankly, the one I recall the most clearly is probably the one when XRP came in with a person who had my position before me as well as enforcement counsel. They were interested in, is there a way to restructure what we're doing to bring it within compliance of the securities laws? And I know this video is getting kind of drawn out and you're probably tired of listening to me read. Full disclosure, I have not read any of this document yet, so this is my first run at it. We're doing this together. I do apologize. Hopefully this isn't boring you guys to death. And the first thing that I said to them was, you're continuing to offer XRP without any kind of restrictions that would apply as a security offering. If you want to come into compliance, you have to stop doing that. And they understood that. So the questions then posed, all right, other than the issues with respect to Ripple, can you identify any lawyers that came to you not seeking a non-action letter but seeking guidance with respect to transactions in digital assets? And of course, he says yes, because lots of people have been seeking clarity. Any other lawyers representing, withdrawn? Any other lawyers you recall coming to you or members of the staff seeking advice on digital assets? The application of the federal security laws to digital asset transactions other than what you've testified to? Yes. I mean, this is a big topic at the SEC, so there's lots of folks coming in and asking for advice on how to comply. I don't want to get into law firms' names or unless you think it's relevant, but other folks at law firms would come in, talk about an idea that would be embedded in a token, and there were a number of folks that said we'd like to do this on a registered basis because we think and we recognize it as a security, and how would we best do that? Could we use Regulation A? Could we use Form S1? Because these were somewhat novel securities, there were questions around what's material in terms of the disclosure you might have to do in that context. We had those kind of discussions with XRP specifically. If they were going to register, what would the things be that would be relevant? So now the questions posed, move to strike about XRP because I asked about your recollection of meetings that did not involve them. Oh, I'm sorry. I missed that. Did you? Did you miss that, Bill? There were frequent meetings. Is that fair to say? Yes. I mean, it was something that happened with some frequency at the division. And when lawyers or industry participants came to you and asked for guidance, I believe you earlier testified that the Division of Corporation Finance did not provide legal advice. Is that correct? That is right. So how were you able to, withdrawn? Let me try this differently. Did you keep a calendar when you were with the SEC? Yes, I did. It skips over again. Will play a role in shaping the future of the regulatory environment in which we and they operate. Yes, he's agreeing to whatever was asked there. We got some more redactions. I mean, man, this thing is like blacked out. Question was asked. So picking up on your testimony with respect to Mr. Sijapanic, I have no idea how you say it. I'm not going to try to read that again. Mrs. S. Yes, I'd like to show you 9. Is that correct? So Mr. Fiegel says, what I'll ask the court reporter to mark as Exhibit 9 and again, I'll represent to you that this is a copy of a page on the SEC's website or available on the SEC website, which I believe is the press release announcing her in the position that you just described. Okay. The date of this press release is June 4th, 2018. Is that correct? Yes, it is. And this is approximately on the date on which you appointed her to be the senior advisor for digital assets and innovation. That is the date it was announced. She was sort of functionally operating this way for some time, but in terms of making a formal announcement of it and creating the actual office, yes, June 4th is about the time. And that office was within the Division of Corporate Finance, correct? That is right. So she reported to you. That is right. And this you testified to earlier, I believe, is one of the examples of an action that you spearheaded as described in the Andreessen Horowitz blog post. Is that correct? Objective form. This is an action that was done under my direction. Question. But would this be an action that would fall within the statement on Exhibit 8 that you spearheaded the SEC's early work with digital assets? It skips over again. It says, okay. For the hot seat, this would be a document that you would have received this morning that has... Mr. Hinman, you're not on this email. So you're free to read it if you'd like, but I'll represent to you that you're not on it. Is this from last night's production? Yes, it is. Okay, I'll explain to Mr. Temrero. You can correlate these to the earlier ones. The earlier ones being yes, blah, 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 blah. Question was posed. I believe you testified earlier, but what was Amy Starr's responsibility on or about December 7th of 2017? At that point, I don't think the FinHub had been set up, which she later joined, so I think she was just a senior person in the division with oversight of novel securities. Did you direct Mrs. Starr to contact Mr. Lubin to set up a meeting with the Division of Corporate Finance? I do not remember doing that. It's possible, but I do not have a specific recollection of asking her to do so. If you'd like to take a look at the Bates number, yeah, more redactions. I mean, you just really want to know what's said in between these things. It's crazy. The questions asked, and the issues as he described it above are issues involving blockchain tokens and security regulations. Okay. Did you have an understanding in advance of the December 13th meeting with consensus as to what specific issues involving blockchain tokens and security regulations that they wanted to address? No, I do not have a recollection of a specific set of topics. This may be an unfair question, but I'm going to ask it. Do you have any recollection of clicking on the links to these emails or reviewing the documents that are associated with these links? This guy says, well, he's not copied on the email, but go ahead. And he says, yes, I was just going to say that I'm not sure I got this email, but I do not remember clicking any links. Do you remember doing any reading before the December 13th meeting? No, I do not. So let's go to the meeting on the 13th. You attended a meeting on that date with representative of Consensus, correct? And guys, that would be Joe Lubin, who's also one of the co-founders of Ethereum. That's where some of this relevance is coming in. Oh, he did. Or did he? Now, some of this stuff I'm not going to read. Do you recall reading this document before the meeting that you attended that you recall as the first meeting you had with Representative Consensus? I do not recall that. I'm going to show you a document that I'll ask the court reporter to mark as Hinman. Again, you're not on this, but I think for the record it would be useful. Okay, blah, 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 blah. It says, I will represent to you that our understanding of the documents we got from Consensus last night suggests that this exhibit was attached to this email that had been marked as Exhibit 16 was transmitted by Mr. Corva to Amy Starr on December 12th. I don't have any questions for you on that, Mr. Hinman, other than I'm just making a representation that our understanding is this was something that was circulated to the Division of Corporate Finance before the meeting. And he says, well, when you say the meeting, they say, well, the meeting. And Mr. Tenrero chimes in, there's no question on the record. I don't have any. Thank you for your representation. I don't think there's any questions pending. There is not, if you could just take a look. And then he says, just so you know, you do keep saying the meeting, and there's a little bit of confusion here because he says he doesn't remember attending this meeting. I think that's hopefully clear on the record to everyone. He says, fair enough. Another question is posed, the meeting that you do you recall any discussions of Exhibit 15? No. Let me direct your attention to Bates, Do you see this? Yes. Is that the project you testified earlier that Mr. Wright was affiliated with in some way? Redacted. Do you recall anyone stating to you at the meeting that you recall in substance what the purpose of what Mr. Wright was working on was to explore the regulatory challenges raised by blockchain technology? I do recall someone saying that to me. Yes. No. In substance, if you could look at the page, I don't recall this slide deck, so certainly not this page. Do you remember anyone telling you in substance that entrepreneurs and others lack guidance on how to sell tokens and should not be securities? From the outside, is that what you're asking? Someone from the outside telling him that? And yes, it is. Do you understand my question, Mr. Hinman? Why don't you repeat it? He says. I'm focusing you on the meeting that you do recall and Mr. Tenrero's observation that you don't remember the date, which I do understand. I think the record's clear on that. I'm now asking you if you recall during that meeting that you remember, you were told in substance that entrepreneurs and others lack guidance on how to sell tokens that should not be securities. He responds with, I do not have a specific recollection of that being said to me at that meeting. No. How about a general recollection? Well, you made a very specific statement. Anything like that in terms of people lacking guidance? No, I don't remember that coming up. And it says if you could turn to the page, I take it this does not refresh your recollection of seeing this slide deck, correct? and seeing this page. It doesn't. All right. So do you remember anyone stating in the substance of the meeting, you remember that entrepreneurs and investors may lack appreciation for regulatory risk? Not at that meeting. I do not recall, no. How about more generally? Do you remember hearing from third parties that entrepreneurs and investors lack an appreciation of the regulatory risk of transactions in digital assets? I did not hear something specifically lacking in appreciation of regulatory risk. I did hear, not at this meeting that we're talking about, but in general, that some people had the idea that if you called something a token, it would not be subjected to the U.S. securities law. That's just by naming it a token, and by creating a digital token, you create an instrument that was subject to securities law and regulation. And that was a perception that you approach, is what he said. And he says that's what he said. The reporter says, hey guys, the record should reflect what he says. Absolutely. Principle-based approach. And then you interrupted. Yes, I just want to caution Director Hinman not to discuss deliberations with the staff. Witness says, got it. Mr. Torero, sorry and thank you. Mr. Figel or Figel, whatever it is, comes back in. Why don't we try this? Yes or no? Did the commission promulgate? I don't know what that means. Regulations that created a safe harbor for the issuance of digital assets during your tenure as the director of the Division of Corporate Finance? No. All right, let's go in. And it says, you gave that testimony, correct? He says, yes, I did. You were under oath, right? Yes. Was it true that you were trying to provide as much guidance as you could to the marketplace? Yes. As of April 26, 2018, had the Division of Corporate Finance issued an interpretive relief about the circumstances under which a digital asset transaction would be an investment contract or a security? Did you say an interpretive release? Yes. No, we had not. As of April 26, 2018, had the SEC, and then that's withdrawn. As of April 26, 2018, had the Division of Corporate Finance issued a regulation about the circumstances under which digital assets, blah, 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 blah. No, they did not. The Division of Corporate Finance had not engaged in any rulemaking activity about the circumstances in which a digital asset would be a security, correct? Mr. Torero says, I object to form and also instruct the witness not to answer internal deliberations about potential rulemaking. Are you talking about rulemaking activities externally, such as requesting notice of comments? Or, and he says yes. He responds with okay. And Mr. Figel starts again. Public announcement of a potential rulemaking as to when a digital asset transaction would be viewed as a security under the federal securities law. They responded with no. And that is all the guidance you could have provided, correct? That's a form of guidance, yes. He goes on, and he's basically, I'm going to start skimming through some of this a little faster, but, he's just going through, he's having no recollection this entire time. I'm going to kind of, you can pause if you want to read these specifically. I'm just kind of skimming, looking for a couple more points that I really wanted to go over. Here you go. And this is where the metadata, and they showed that some stuff had been deleted. Even if it is, you can ask him, did you direct him? I don't recall directing him to delete it. Do you have an understanding as why he would delete these subtopics and without, I don't have a specific recollection of reading that particular deletion here. I think he may have been looking for a broader question rather than something that was characterizing some of our advice or our guidance in this area. This looks very narrow, and we might not have agreed with the premise of the question. Well, do you agree that one of the key points of your June 14, 2018 speech was that the token and the offering may be distinct? The token may be offered in a securities offering at some point in the future. The offerings may be non-securities. Nonetheless, the touchstone of the analysis is likely the Howey test prong regarding an expectation of profit solely from the efforts of others. A sufficiently decentralized network token does not rely on the efforts of others. He objects. He's like, do you want to break that up? He says no. Mr. Torero says it's impossible to answer that. Do you disagree that was a key point of the speech? He's objected again. And then Hinman has responded with, I think that is too narrow of a reading of the speech. I think it's, again, why Michael may have deleted this, as the premise of this was, these were the key items, and I think it was reducing a 5-page speech or 6-page speech, whatever it was, to one paragraph. And I already read you guys this. It's basically where, when you call 10 different law firms, everything comes out all jumbled up with different answers. It says, did you direct Mr. Seaman to delete the portion of the proposed questions? I don't recall directing him to do that. It's hard to tell from the way this document's presented whether he added the statement. Another issue is that the outside observer is that the SEC can be opaque with all the different divisions and offices. How do we know who to call? It looks like that's something he added. It was probably trying to give me an opportunity to say, here's how you can get your answers to the questions you may have. Do you believe that Mr. Seaman wrote, you call 10 different law firms, they give you 10 different answers? No, I think that is struck out in the documents I have in front of me, so my guess is that is either a very long 3-paragraph, almost full-page question, and he may have deleted it for any number of reasons. It's fair to say that the moderators believe you could call, that same issue. And he's like, I'm just going to note objection. Judge Netburn has ruled on your fair notice defense. The focus is not on what the market participants believe. It's an objective test. You're skating dangerously close, in my opinion, to opening the door to what people believe, including your client. And go on if you'd like. He says, noted. Can you answer my questions? Sure. I just want to make sure, answer the question, okay? I don't know what moderators thought when they were coming up with these questions, what was in their mind, if they thought it was a colorful way to describe a question or ask a question. I don't really know what they had in their mind. It's hard for me to read someone else's mind. But you do have no reason to believe that Mr. Seaman added that portion of this document, correct? No, again, I think this was a deletion, but I don't know the history of the question, who initially drafted them, who changed them, but my best guess would be that Mr. Seaman added the language that's in red, but not struck out and struck things that are not. You can just see, man, they're very dodging in a lot of this stuff. New insights are based on who can get a meeting or which lawyers say they know someone in the right office. There have been some efforts to avoid this and try to bring the conversations on this topic into an open forum and find consensus on best practices. Do you have any reason to believe that Mr. Seaman added that? Same answer. Same set of questions all the way to the bottom. Any information about who added the language and who deleted it? No, again, I think that things are in red, such as do you have plans to issue more guidance were likely added by Mr. Seaman and other things I just don't know about the editorial history. I'm going to pause at each one of these pages as I scan. That way, if you guys want to actually read the entire thing, you can. I'm trying to find just some of the more juicy stuff here. Talking about another potential meeting, some of these people. I'm probably on the wrong page. Give me the page number again. He says, from a practitioner's perspective, the situation in the cryptocurrency markets is extremely unusual. Token issuers can speak to two different well-regarded, experienced law firms and get diametrically opposite views on the current and future applicability of federal securities law and what steps the token issuers need to take to engage in compliant token offering. So, I mean, that tells you right there, there's no clarity. I mean, he's literally telling you that, yes, from a practitioner's perspective, it is extremely unusual. Do you know whether Mr. Clayton has a relationship with Consensus or Ether and any of the entities in the Ether network prior to his joining the SEC? He says, not that I am aware of. Are you aware that Sullivan Cromwell represented Consensus and that has been objection to form? He says, I didn't know if they were a firm client. I think some of the people at Consensus meeting had a Sullivan Cromwell background. I don't know if they were still there appearing as, the law firm for Consensus, so I wasn't aware if they or of the relationship. Now, you testified earlier the SEC had policy against owning digital assets for quite some time. Do you remember that? Do I remember testifying to that? Yes, I do. And when you first became aware that the SEC had a policy against owning digital assets, this is way beyond what you were ordered to ask him about. When did I become aware of the policy? While I was at the SEC, probably the first year. And they're still going on about that. It says you're talking about two different things, aren't you? You're talking about a conflict of interest policy as opposed to a policy against owning digital assets. He says, I'm talking about policies that might restrict someone from owning digital assets. Did the policy against conflicts of interest restrict people from owning digital assets if they didn't have any conflicts of interest? And he's like, I'm not sure how the policy would have been applied at that point. He's like, you then stated that you did not own digital assets, correct? Yes. Did you own any stock in any company that did own digital assets? He says, are you talking about at the time of the SEC? Yes, I am. Okay. Not that I'm aware of. Did you own stock in Alibaba? No. Did you own stock in Ant Financial? No. They're tying together the whole China thing right there, guys. Lots of redactions. Lots of redactions. It says this policy, let me see. Am I correct, sir, that this policy with respect to ethics conflicts among the staff? Correct? Right. This policy does not prohibit anybody from owning Bitcoin. Isn't that correct? Does it prohibit owning Bitcoin? I'm sorry. Yes. Well, again, looking at this quickly, I own Bitcoin. The document has a question. I own Bitcoin. I've been assigned to a part of a working group of the SEC making recommendations with respect to Bitcoin. Can I do this? The answer is no. Then it goes on to cite parts of the U.S. code that say federal employees are prohibited from working on any particular matter where they may have a direct or particular effect on the employee's financial interest, and then they go on to give examples. So am I correct, sir, that if you were not involved in making recommendations on how to regulate Bitcoin, you would be able to own Bitcoin by the SEC? He says, I'm sorry, could you ask the question again? Does this refresh your recollection of the employees of the SEC that they had conflict of interest with permanent owners of assets? It says, again, that if they were not involved in the space in any way, which that's a pretty broad, SEC views these things pretty broadly, so potentially I think you could own Bitcoin if you were involved in something completely away from it. And would you actually need permission to buy Bitcoin if you were in that position of not having anything to do with the regulation of Bitcoin? He says, I'd have to refresh myself on the security clearance procedure. If you buy securities, you're supposed to get them pre-cleared. Am I correct that the digital assets were not covered by the securities clearance form until 2018? Again, I'll take your word from that, but it says, didn't you help write the policy in 2018? I don't remember specifically helping on the policy. I probably had conversations with people on the staff about it. I want to point your attention that it also says in this document that the OEC has been informed that the status of Bitcoin as either a currency or securities is undetermined at this time. Did you see that? Yes, I did. As far as you know, was that true? With respect to the ethics office, this document speaks for itself. Did there come a time when the status of Bitcoin as either currency or securities changed? And he says, for what purpose? For the purpose of regulations for the Department of Treasury? I don't know what Treasury has applied in terms of their money laundering rules to Ether. I don't know off the top of my head. And what about with respect to Bitcoin? I'm not sure how they are applying these rules to those two assets. Now, you mentioned in response to Mr. Figgle's questioning that you were not aware of any rulemaking proceedings that you were involved in connection with digital assets. Is that correct? He says rulemaking proceedings is very broad, so we did a lot of rulemaking while I was at the SEC in my division and other divisions. You asked broadly, would they apply to digital assets? If someone was in the business of, mining Bitcoin or pick a digital asset business and they were a registered company with us, the rulemakings would be relevant to them in terms of disclosures. So you're asking a very broad question. If you mean, are there specific digital asset rulemakings that I was involved in? I don't think we had a specific rulemaking per se. Yes, that's what I was getting at. This stuff is just crazy, man. Do you recall that any that were specifically related to the applicability of the securities law to digital assets in 2017 or 2018? I don't remember when we issued the pocket full of coins, or there was, I forget the name of it, a jet token that the dates of those are. Maybe you do. Is that the only case that you remember, or the only one that you remember? I think there were some others, but I might have been less involved with those. Again, you've asked very broadly if that applied to digital assets. He goes, I changed the question slightly, and he says, okay. And he says, to involve the application of security laws to digital assets. Again, I remember the two, and I'd have to go back and do some work to see if there were others that were relevant. But there wasn't a plethora of no action letters issued by the SEC in this space during your tenure. I remember the ones I remember. So, the two, yes, okay. Actually, I think there might have been a third, but again, I'd have to go back and look. Mr. Fidgel showed you the Dow Report that was in 2017, and he agrees. That was issued a couple months after you joined. He agreed there. What role did you play in the issuance of that report? He goes, I reviewed it, I commented on it, I talked to different members, enforcement about it, talked to the chairman's office about it. He's talking about the meetings here, the securities office are on Zoom calls. Was Mr. Garlinghouse at some of those meetings? And they're talking about, these are meetings that were representatives of Ripple in connection with the SEC staff investigation of Ripple. And he says, I think he may have been at one or two of the early meetings. And it says, what about Andrew as Serenity? Or let me get my glasses. Seresny, do you know who that is? Do you know who Andrew is? I do. Who is that in connection with this case? I believe he was Ripple's counsel and formerly the director of the Division of Enforcement at the SEC. What about Meredith Cross? She attended some of these meetings and is a partner at Wilmer Hale and formerly held the same position I formerly held, director of the Division of Corporate Finance. Did you have meetings with either Mrs. Cross or Mr. Seresny about the SEC staff investigation of Ripple's conduct? Yes, I did. Have you ever at any time told the Ripple's representatives that you did not think their offers and sales of XRPs were security transactions? They're kind of arguing here. He's saying we're going to ask for, this is an external statement. We're going to ask for notes of his meetings. You're opening the door to things that you've claimed privilege on. You've asked for those notes already. We're going to get them this time, so go ahead. Have you ever, Mr. Hinman, at any time told Ripple's representatives that you did not Objection. No, I have not. Have you ever told Ripple's representatives that the SEC itself or any of its commissioners did not think that Ripple's offers and sales were securities offers? He says no. Did you ever witness anyone at the SEC tell such things to Ripple representatives? He says no. What did you tell Ripple's representatives at these meetings about sort of your views and only communicate with them what you told them externally? A number of things. So it's a broad topic. When Meredith Cross came in with Andrew, one of the purposes of that meeting, as I understood it, was to try and bring the company into compliance and to examine ways that could happen. So one of the things I told them was the first thing you need to do, and I'm kind of surprised you haven't done it already, is stop selling XRP on an unregistered basis publicly. We also told them that they were concerned, or that we were concerned about the asymmetries between what the people at Ripple know about the prospects for XRP and what the market knew, and we explored with them the idea of Ripple becoming a public company to help reduce the asymmetries. Did you say help reduce? Anything else you recall generally that you told them in these meetings? Yes, I think I expressed concerns about did investors have all the information that they should have about the prospects, and did they get that on a timely basis? I expressed these concerns about the lack of transparency. Can you give us a time? But in terms of the years, I think you said the last few years. Are you talking about the last few years as your tenure there? Yes, I'm sorry. So that would have been probably, I think some of these meetings began in 2018 and some early meetings with the XRP representatives, general meetings, and then meetings trying to figure out how XRP could come into compliance were later, probably in 2020. It says setting aside meetings with other members of the government. Did you ever tell any person outside the SEC that you did not view Ripple sales of XRP as securities transactions? So I'm talking about third parties only. No, I did not. A lot of objections, man. It says, did you ever witness any person from the SEC tell any person in the, again, outside world, not the U.S. government or other governments, that the SEC did not view Ripple sales as XRP as a security transaction? Some more objections. He says, no, he didn't. Did you have a meeting with Chair Clayton and representatives of Ripple sometime in 2018? I believe they came in to meet with the chairman. Yes. Did you ever hear Clayton tell anyone at Ripple that Clayton did not view Ripple's transaction as securities? No, I did not. Did you ever hear him give assurance to anyone at Ripple that the SEC would determine that Ripple sales were not securities? No, I did not. Again, I'll stop at these so you guys have time to read if you want to pause. I'm just trying to hurry up. I didn't realize this video was going to run this long. I thought there was a lot more redactions other than the many that there are. It says, okay, and so just to be sure and to wrap up things on the prior point, setting aside this meeting in this document, Mr. Hinman, I just want to be sure I understand you. You at some point told Andrew Seresny, in his capacity as Ripple's attorney, that you thought the XRP transactions might be problematic under the securities law. Is that correct? And his lawyer says that's inconsistent with his testimony. So he reframes some of this. Or no, he asks the same question. The leading is really inappropriate with the commission witness. He says, okay, can you answer, please? Basically, my answer would be what I remember telling Mr. Seresny and Meredith Cross about my views on the asset. That I viewed it as a security, and I viewed the continuing offerings, periodic offerings of XRP in a way where they were not restricted in the way a securities offering would be restricted, and therefore exempt, or they weren't registered as a problem under the securities law. If they were interested in coming into compliance, they should start by stopping those sales. Based on the meetings you attended, in the conversations with Ripple's representatives, did you have any reason to believe that Ripple's representatives did not understand the security law principles that might apply to their conduct? He says, I had no reason to believe that. Meredith is a very accomplished securities lawyer. It says Meredith occupied your position as head of the corporate finance or Corp Fin. She did, and she said to you that in her view XRP was not a security. He says, I don't think she ever said that to you. And they asked, she never said that to you? He says, I do not recall her saying that. And it says, Mr. Serezny was the head of enforcement at the SEC. At some point in 2018, it was said that the sales of XRP may violate securities law. Is that what you testified to? He says that I had a view that their sales violated securities law, and yes, that's what he said. Just to be clear, in 2018, there was no preliminary injunctive relief that the commission sought against Ripple in relation to any sales of XRP. Is that correct? Yes, it is. And that is also true in 2019. Correct. And it was also true in 2020. That's right. In fact, the lawsuit wasn't brought against Ripple in relation to any of its sales of XRP until December 22nd, 2020. Correct. And he says, if you're going to keep asking him facts that are in the record, we're going to instruct him to finish the deposition and you can call the judge. He says, I'm trying to move through this quickly so that you'll give me a few more minutes. And it says, Matt, it is in the record when the lawsuit was filed. Is that correct? When was the lawsuit filed? Yes. I've not examined the record, so I don't know the date. Was it in late December of 2020? I don't know. I think it was December 20th, December of 20, on the 22nd, somewhere in that range. Fair enough. And when the lawsuit was brought, was there no preliminary injunctive relief sought in relation to the sale of XRP? Is that your recollection? Not that I am aware of. And says, no, there was no preliminary relief sought at that time. I wasn't at the SEC at that time, so not that I'm aware of. He's talking about a meeting where Brad Garlinghouse was attended. He says this looks like a post-speech memorandum attached by two individuals. Yes, I just want to... Sorry, this is a one-page document. Okay. It was a short meeting. It says you gave a speech on August 20th of 2018, and you gave your view that neither Ether nor Bitcoin were securities. Is that correct? Yes. And in this memo, there was a discussion involving my client and Schwartz. Is that David Schwartz? I believe so. That's what the memo says. All right. About Ripple's business and technology, that's when the memo writes, right? Correct. It also looks like there's a notation that towards the end of the meeting, Garlinghouse briefly noted that Ripple was in purgatory due to the uncertainty as to whether XRP, the cryptocurrency with which Ripple is associated, or is not a security. Do you see that sentence? I do. Okay, so the two individuals who attended that meeting were reporting back to an internal memo that at this point in this time, my client had orally indicated that there was uncertainty around the status of XRP. That's what this memo establishes, right? And it says that is what the memo says. Do you have any reason to believe that this memo inaccurately reflects what my client said during that meeting? No, I do not. So that tells you right there that back in 2018, they were literally telling the SEC that you guys are not giving us sufficient clarity for us to make proper decisions. It says, in response, the Chairman Clayton immediately stated that the meeting was not the proper forum for the discussion on the topic. So there's no note in here that Chairman Clayton responded that there is clarity around whether XRP is a security, right? And it says that is not in the memo. I don't see it in the memo. Do you? Because I don't. It doesn't matter what I see. Do you see it, Mr. Hinman? I do not. Neither do I. Let's move on. Then it says, he asked Brad Garlinghouse to back up from that issue and steered the meeting into a discussion about Ripple's business and technology. Do you see that sentence? Yes, he does. The last sentence of the memo states, following further discussions of these issues, the memo concluded that Chairman Clayton encouraged the Ripple executives to continue ongoing discussions with the staff in the Division of Corporate Finance, which Hinman says he did see. Is there anything in this memo that indicates Chairman Clayton was of the view that the sales of XRP was a security as of August of 2018? And it says, you mean other than when he tells him not to talk about that with him? It says, that wasn't my question. Is there anything in there that suggests he says that XRP was securities? Do you see that? And it says, I do not see him saying one way or another anything about the characterization of Ripple or XRP. It says that would have been a significant piece of information had he said that, correct? He responded with, I think the chairman was steering the conversation away from that topic because I think he was aware that people were gathering more information about XRP at that point. Okay. Is there anything in here, Mr. Hinman, that indicates that you expressed a view at this meeting that you believe the sales of XRP were security sales at this point in time? No. And he says, that's all I had. We're done. You guys have spent more time than we did on these questions. If you want to move to bring him back, we'll see your motion. He says, Jorge, and he goes, look, he's been here for 11 hours. He's been here for 11 hours. You showed him about 20 documents he was not even copied on, with Rob Cohen on them and with other people on them. You've had him for 11 hours, and you could have asked him all these questions. And then it just goes on to say, as I understand your testimony, both in response to Mr. Terrera's questions and Mr. Flumenbaum's questions about the meeting with Ripple or representatives of Ripple, there was a meeting that you attended in December, sometime after December 11th, when you apparently resigned, but before you were off the payroll. Is that correct? Yes. I wasn't officially resigned until December 20th, I believe, or 18th, something like that. Because of the amount of unpaid leave I had accumulated, I was in effect taking a vacation, but I had additional people calling me with questions during that period. It says, so you attended the meeting by Zoom with Ripple representatives? I believe so. There was also a meeting, I believe, in September that Mrs. Cross, Mr. Seresny, and various other people attended. Correct. You would know the date better than I, but yes. And then it talks about in August, yes. It says, now directing your attention to the meeting in September where you answered questions in response to Mr. Terrera about where you said to Ripple. Right. Did you prepare talking points prior to that meeting? No, I did not. Was there a memorandum or a transcript made of what was discussed at that meeting? Not that I'm aware of. Imagine that. It says, now, you have testified that you didn't have a specific recollection about what was discussed in December, the December 2020 meeting, correct? Yes. All right. And with the September meeting, obviously, with a few months before that, yes, it was. Yada, 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 yada. Do you have a specific recollection of the words you spoke on the issues of bringing the company into compliance? Yes. What specifically did you say? This is probably not verbatim, but I think the beginning of the conversation was we understood you want to come into compliance. If you want to come in compliance, you need to register these sales or stop these sales that you're doing periodically on. I remember expressing a surprise that they had still been ongoing. And you remember speaking these words. You're not describing what you said. Those are the words you remember saying. Is that correct? Again, it's probably not verbatim, but that was the message I was providing. And he says, I'm not asking about the message. I'm asking about the words. And Hinman says, okay, the words I think I stated were that I'm very surprised to see you are still offering XRP on an unregistered basis. You're here to talk about how to come into compliance. You should stop doing that before we even think about anything else we could do here. And what did Mrs. Cross say in response to that? I believe she said she understood. Basically, her response was one of, I get it. Do you remember the specific words she said in response? I do not. How about Mr. Seresny? I think he did not have much to say about it. And then he goes on to say, did you refresh prior to your testimony in connection with the preparation for your deposition? Did you review any documents that refreshed your recollection about what was specifically, and I don't know what it goes on to say because it then ends and you have the court reporter finishing off with whatever he is saying. So this thing is building up, guys. You have this, you got the Freedom of Information Act that's been applied or attempted to be applied by the watchdogs. They want some of this stuff unredacted, I believe, and provided to the public, which I think it should be. I want to know what the hell was talked about outside of any confidentiality, naming of clients and stuff like that. I think a lot of this stuff is probably pretty relevant, and that's why they've had it redacted at this point. It will be interesting to see where this goes. I'm going to get off here. This video has ran long enough. I do apologize for that. I hope those of you who made it to the end did find this useful and informative. Remember, nothing here is financial investment advice, anything like that. This is for education and entertainment purposes only. This is just something I am passionate about. Making YouTube videos is a hobby of mine that I really, really enjoy, especially relating to the topics of digital assets and mainly XRP. So with that, guys, enjoy the rest of your day. It did look like the market was starting to bounce back just a bit. Let's hop on over to TradingView and see what we got number-wise. It looks like the total market cap is still back up. We're coming back up here as well. XRP is almost back up to $1.20. Solana just smashing through some more. XDC looks like it's on a rager. We're almost up to 16 cents. All-time highs being approached. Bitcoin is creeping back up to 46,000. Yeah. Here, Cardano's back up to almost $2.15 out of nowhere. Guys, remember, we are in the middle of a bull run. It is getting ready to start back up. This is my opinion. This is speculation based on tons of research. And remember, this area here, we know that it's heavily reactive. It has came up, bounced off of it multiple times, and it looks like right now we're working our way back up. So pay attention. This thing could roll over on itself, but I got a feeling with everything building and the narrative and the sentiment and everything going the way it is, greed is still on the table. People have yet to begin FOMOing, and when that happens, we're going up here, guys. That's my firm belief. I'll catch you guys on the next one.